So let's look at the Li Chengxing Tong case, which is a very interesting case. It's a family firm. You may be familiar with this firm. And it is a case in which the family is relatively large. So Mr. Li has two marriages. And then in his first marriage, he produces quite a few children. About, I think, 12 children. And then his wife, obviously, that's a lot of strain to produce 12 children, and the wife passes away, and then he remarries to someone named Karen. And Karen also, together with Mr. Li, produce a couple of children, right? So, and then Mr. Li passes on. And so this is a case in a family firm that you can see we have, something, the evil stepmother, right? So it takes on a sort of a storybook connotation with Karen entering the Li family relatively late, her husband passing on, and then Karen having a large shareholding and going into the board of the company. Now, what Karen does is not really all that evil stepmother-like. Actually, she has some pretty interesting ideas. And the company produced a Po Chai pill. Now, the state of the art would be something time released, which would be something like a capsule. And so Karen suggests that the Po Chai pill be supplemented by creating a Po Chai capsules, right? And this is the new idea that Karen brings in, which you can see is a relatively rational sort of thing to do, to bring a family firm which is already successful with a broad customer base into a more modern form. The problem occurs when she brings in a couple of people, Mr. Wang and Mr. Zheng, and she then entrusts them to find the manufacturing facilities for the Po Chai capsules. And so the Po Chai capsules, what everyone is imagining, of course, would be something like this. We have a modern factory, perhaps located in Shenzhen or someplace close by, which meets every imaginable pharmaceutical standard. Unfortunately, what we ended up with was kind of an old factory someplace in Guangdong that was also producing Western drugs, so the kind of drugs that are not respected in Chinese medicine. Now, so the factory was producing Western drugs, and then it was also producing the Po Chai pills. And as you know, for example, if you're a vegetarian, that it's not a very good thing if you go to a restaurant where they use the same spoon or the same pots to cook food which is based on meat and the vegetarian dishes, right? And this is the kind of thing that we end up with in producing the Po Chai capsules. So what happened is, probably to the glee of the Singapore authorities, it was Singapore that discovered that the Hong Kong Po Chai capsules included the Western drugs. Now, that is a shock to have residues of Western drugs inside of the Chinese medicine Po Chai capsules, which immediately damaged the company's reputation. And this is then the source of the derivative action against Karen, Wang, and Zheng. Now, to her credit, Karen mobilizes and has an independent consulting agency prepare a study on how this mistake occurred and how it can be corrected in the future. And that will then come into the derivative action. So then what we have is from Justice Harris in the Court of First Instance, a reminder that the threshold is low, right, for a derivative action. Because what we're looking at is simply whether the action can go forward, whether leave will be granted to allow the action to go forward. And then if the prospective claim is not against the directors, the board's view of what will be in the commercial best interest of the company should generally be given considerable weight. And this is where Karen's study comes in. So Karen conducted this study and basically said, okay, we have taken care of it. We now understand what we did wrong, how we can correct ourselves, and we have a plan of action to do that. And so litigation will not be in the interest of the company because litigation will bring this out into the public. It will be in the papers. It will augment the report from Singapore, further damaging our reputation, bringing out all kinds of internal secrets about the company. And so therefore, it is not in our interest to take this into a public forum. However, the court finds here a couple of things, right? So one is we have this relatively low hurdle for the derivative action. Two, when we have a serious question, which is a serious breach of duty, and here we do have a fairly strong allegation of a breach of duty of care because the kind of factory that was producing the Po Chai capsules was not sufficient. And so therefore, when we do have a strong allegation of a serious question, then there will be a tendency to find that it is in the interests of the company, right? And so if you have a board who is involved in the action and is partly in the set of defendants, the decision and the judgment of that board will not be given as much weight, right? So you see how the board's judgment on what is the interest of the company here resembles to a certain extent what we saw in the David Chen case, that when there is a conflict of interest, we do not entrust the board with sole discretion over what is in the interest of the company. Please do not confuse this analysis with that found in the David Chen case. They are separate. However, they are similar. And what I want you to understand is there is a difference between how the court observes directors with no self-interest and directors with self-interest. So I take a look at these. These are just snippets. I'm essentially highlighting the case for you. Probably I shouldn't do that, but you might find it useful. So now we've got a different sort of a case, and it's quite interesting because the Lee case, you have an action which is sort of the traditional and older relationship between Hong Kong and mainland China. So the Lee family is producing their Po Chai pills. Karen takes the production into mainland China. The regulatory standards in mainland China are not as high, and so the Western drugs get into the capsules, which causes problems and damages their reputation, right? So basically, then the moral of the story, one of the morals of the story, is watch out when you move things into mainland China because the standards could be low. And this is how Hong Kong has earned its living for quite a while, with strong law guarding investments going into mainland China, particularly large IPOs. Now, what we have in Zhang looks more like the current state of affairs. So this is 2017. And so I'm not saying that these are always the case, but you can see an indication that things are a bit different here. Because Zhang is in Shanghai, right? And she's dealing with Shum, who is in Hong Kong. And because Zhang in Shanghai cannot watch Shum in Hong Kong, Shum starts misbehaving. And so here we have the upright Zhang Heng from Shanghai trying to get Shum in Hong Kong to meet the standards that Zhang would like to see Shum meet. So you see it's a bit of a reversal, and it shows how this evolution has been happening in an extremely rapid manner. But it has meaning for Hong Kong because Hong Kong has been selling its law to the world as a regulator which can guarantee against a certain amount of misbehavior in mainland China. And when the misbehavior becomes less likely, then Hong Kong must, in a certain sense, adjust its business model in terms of the kind of law it sells. And that's why Hong Kong is moving more toward innovation and away from a kind of a police state sort of rigidity. So in any case, let's come back to Zhang and Shum. So Jiang and Shum have a company, and they call it Kingston Wealth. And Kingston Wealth sells a kind of sophisticated uh, uh, wealth or savings and investment product that has some resemblance to an insurance contract, right? But it's not an everyday run-of-the-mill insurance contract. Now, Shum is then this is in Hong Kong, that's why we have the case, and Shum is the director of Kingston Wealth, right? And Shum then sets up Kingston Financial Group to hold her shares in Kingston Wealth, right? So we have a number of companies with this Kingston name, right? And we have the two major shareholders, Shum and Zhang, in Kingston Wealth. Now, Shum then sets up another company called Kingston Advisors. And what Shum does is decide to license Kingston Advisors for dealing in securities and providing advice on investment in securities. I'm using the numbers here of regulated activity 1, 4, and 9 from the Securities and Futures Ordinance, Schedule 5, if I remember correctly. And you can see there the list of the 12 regulated activities. So this is a case that you really want to think about Jason Poon, okay? Because this is coming up about the same time, and it falls almost directly into the ratio decidendi, which is discussed in Jason Poon. Shum is a director of Kingston Wealth. Shum indirectly sets up another company, Kingston Advisors. You can think about Ricky Cheng here. Kingston Advisors then seeks to be licensed for activities that Kingston Wealth is not specifically providing. So what then, at the court of first instance, the Justice Harris looks at the scope of Kingston Wealth's business as agreed by Jiang and Shum. So again, you can think of Jason Poon, Daisy Poon, and Ricky Cheng, and then how they decide on SmartWave and whether it should own one or many sushi restaurants. So here we're looking at Jiang and Shum, and we're trying to understand, what did they agree? What did they agree would be the scope of the business of Kingston Wealth? And is Kingston Advisors competing? Right? And what we have is a decision by Justice Harris that no, they are not competing, right? Because Kingston Wealth is primarily involved in a kind of sophisticated insurance product, and Kingston Advisors is doing something different, and that also Kingston Wealth did not have the funds necessary to be licensed in activity 1, 4, or 9. Now, this is appealed when Justice Harris finds that there is no leave that will be granted to Jiang Hang, and in the Court of Appeal, we have Justice Madame Kwong deciding the case, who then reverses Justice Harris. So in many ways, this is an interesting case because it is very modern. If you see that the two partners are women, the plaintiff is a woman, the defendant is a woman, and also the judge in the Court of Appeal is a woman. And also we have the reversal where the alleged misbehavior is taking place by the Hong Kong participant, and the clean person who's looking for justice is coming from Shanghai. And so there's a lot, this is a very modern case because there are a lot of stereotypes which are being broken, okay? So Justice Kwan, in reversing Justice Harris, cites Justice Harris's own decision by reminding him that he had written earlier that the odds against success no longer defeat the plaintiff unless they are so long that the plaintiff can have no expectation of success, but only a hope. And Justice Kwan points out that there's certainly much more than a hope here, given the nature of the two financial companies' business, and then also some correspondence which showed Zhang's intention and hope together with Shum to increase the capital. Right? So the Lee case and the Zhang case are excellent reading on derivative actions, and we will discuss those more in class. What we're left with is one relatively unimportant provision, but you should know about it because it's quite interesting the way it applies, and it's the possibility of seeking an investigation to provide you with more evidence in the stage when relief is simply that leave will be granted, right? And so this provision exists in the context of a derivative action, but it is very difficult to meet because we do have Section 740, which we'll talk about in a couple of weeks, whereby a member can ask for certain information regardless of whether it's for a derivative action or otherwise. And then we do have the possibility that if leave is granted, there will be the possibility of investigation. And then beyond that, we have the fact that leave will tend to be granted in the sense that it's a relatively low hurdle in order to get leave granted. And so bringing in the expense of an investigation could be unnecessary. So as I said, I bring this to you because it is an interesting section, and the way it is applied by the court teaches us something about the policies behind the engineering that's put in the derivative action to allow members to go forward when there is damage, but stop those actions from going forward that simply appear to be the minority dominating or attempting to dominate the majority. So this is the derivative action. It's a fairly simple lecture. I'm sure the elements of the derivative action are something that you can learn very, very quickly. And we will spend time on the application of law problem, looking once again at the duty of care and the fiduciary duty as basically the serious problem component, or the serious question of law component in deciding whether leave should be granted to go forward with the derivative action. And I look forward to those discussions with you.